I do believe there were a few questions that were left over from the last two presentations and probably from Harry's from yesterday. So why don't we just open up the floor right now, and I'll hand the mic back over to Angela, and maybe we'll run around and see what questions we have for our distinguished guests.
Sure, thank you, Celeste. We had Alan graciously agree to hold off his question until we got the panel together.
Thank you. Hello, my name's Alan Cummings, and I've got the huge pleasure and privilege and honor of working with the hereditary chiefs of the Wet'suwet'en, the Wet'suwet'en hereditary chiefs. I've got a question, I guess it speaks a little bit to the nature of title, and as well as government-to-government relations between ourselves and the province. We were recently briefed by our legal counsel who held meetings with senior provincial legal counsel, who amongst things talked about title and issues. They talked about issues of overlap. Wherever there are issues of overlap, those lands are not subject to title, and they're at default to the Crown. They're Crown lands, effectively, as well. And then talking about the nature of title, they made a comment with regard to subsurface mineral rights and mining, which were explicitly discussed in the Delgamuukw-Stayaway case. They've made reference that those were mere musings of the Supreme Court, that they were actually obiter dicta and not defined components of the ruling. So I'm just kind of curious about your perspective, because it seems like for us, every time there's an advancement made in relation to Aboriginal rights and title case law, there's a counter effort by the province to minimize, marginalize, or just outright reject those advancements. Because I know there was a comment made the other day that justifiable infringement, well, at least the comment seemed to me, it's something that is kind of unlikely, or there's such a high threshold if there was going to be an advancement by the province on justifiable infringement. But I don't share that view at all. I think that if there was a proposed natural gas pipeline through the Chilcotin tidal area right now, the province would be doing everything in their power to work towards a justifiable infringement to get those things through. So I guess my comment is just that the nature and scope of title, and in relation to that new position that the province is taking on with regards to mining and subsurface mineral rights not being an element, or being their interpretation, I guess.
Well, I'm a little bit at a loss to understand how it could be said that subsurface resources are not included in title, where title has been established by declaration or by agreement. Even if what was said in Delgamuukw is obiter dicta, it's obiter dicta from the Supreme Court of Canada. And I don't know that any serious person could anticipate a different outcome should the matter go back to the court.
Well, I agree that the court should be consistent, but as I was pointing out in my remarks, the court views evolve. I wouldn't expect a change in that regard. But I think the general tendency in litigation is for the loser to minimize the loss and search the judgment for redeeming features that they can fasten on. And the lawyers are very good at explaining to the client that it really wasn't as big a catastrophe as they might think. So there are very few judgments that are so clear that the loser simply capitulates further resistance. And I think that's just part of the litigation process, and I think you just have to keep hammering them. I think what is important is to go back to the court. An example out here was in Little Sisters and the lesbian bookshop where the customs was hammered for their treatment of the importation of this material, and customs really didn't pay much attention to it. And they went back to the court. And I think that then gives the court the opportunity not only to reinforce the message, but to do so in much stronger language. So I think in the case of these mineral rights, If that's the position being taken, you've got to somehow get it back to the court, and then the court will leave no doubt.
Thank you. You done
Just,
here?
if I may, you also mentioned overlaps and positions that have been advanced with respect to those. Well, the idea that where there's an overlap, the default is necessarily to a clear, clean Crown title doesn't seem to fit with findings in the Supreme Court that indicate joint title is a possibility. But more generally on the subject of overlaps, where overlaps occur in claims brought by the same cultural linguistic group, there's a very good reason for them to find a way to work together by aggregating their claims. And let's face it, there's power in numbers. And if Indigenous groups can go forward in a negotiation, being able to say to the Crown, provincial and federal, that you make treaty with us and you've got all of our territories covered. And certainty has been established in the interest of the nation and the Crown.
Thank you. Question over here.
Gisuk Yukit. I'm Cheryl Kasmer. I'm with the First Nations Summit. Given it's my first time speaking, I'd like to acknowledge the traditional territory of the Squamish, Tsleil-Waututh, and Musqueam people, and for having them allow us to do this business on their land. Secondly, I want to express appreciation to the Treaty Commission for holding an awesome forum. They did an awesome job last year, and they've done another awesome job again this year, so I thank you for that. My question is in regards to reconciliation. Honourable Binnie, you made a comment about needing to get our act together and how it's more beneficial for us as First Nations to table proposals or to table agreements with government and put them in the reactionary position as opposed to us always reacting, and I agree with that. Given the comments from Prime Minister Trudeau in that he has committed to working with First Nations in the development of a reconciliation framework. He said he will do that in partnership with us. I'm interested in knowing, even though we have our own idea of what that might look like, I'm interested in knowing from your expertise what you think should become a part of a reconciliation framework agreement.
Well, I think, first of all, as I mentioned, reconciliation is a two-way street. I think, the courts are have a split view. They want to do the right thing by First Nations, but they're concerned about the consequences, both in disruption, the non-Aboriginal society, economic activity, and there's always this tension underlying litigation. So that, for example, it was relatively easy in Chilcotin, in a area of the interior, to make broad statements about Aboriginal title. There are places in British Columbia where it would be very tough to reach that conclusion and to say those same rights, equivalent to a kind of super fee simple in some ways, apply. So it seems to me that the basic proposition of reconciliation is that there is a mutual respect for the interest of both sides and some kind of mechanism to iron out differences that arise by some means that both sides consider acceptable. There has to be the principles, and there has to be the mechanism in order for it to work.
Yes, and I would just add that any protocol or that has to do with reconciliation, if it's going to apply generally, seems to me to need an understanding by government and Indigenous groups of what it is to be reconciled with what. Justice Binnie talked earlier about the earlier notion of reconciliation being Indigenous peoples reconciling themselves to the sovereignty of the Crown, and that's been turned around. The idea now seems to be that the interests of Indigenous peoples and the Crown are to be reconciled with each other. Okay, so what are we talking about reconciling here? So from an Indigenous perspective, it seems to me you'd want to know in the general framework whether we're talking about Indigenous interests in land and resources, whether proven or not. Because if all you're talking about is in British Columbia, land that has been declared title land or treaty land, then it's a very limited discussion and perhaps would not lead to an outcome that's satisfactory from an Indigenous perspective. With respect to governance, you'd want to ensure that everything that is meaningful to Indigenous peoples in the way of self-government and governance of land and resources is in the picture. Because if it isn't in the picture and you seek to raise it in a particular negotiation, it will be said, well, we never anticipated getting into that.
Say welcome back to Judge Point. You came in without hearing the question, so let's fill you in on that a little bit. The question that is being asked is, based on the experience of the panel, what might you recommend that First Nations look at putting into a reconciliation framework? Correct, Cheryl?
Wow. I think that we run into problems when we try to use terms like reconciliation. It's an English word, right? And often when I'm reconciling my bank account, I can't do it, right? It doesn't work. Or if I'm trying to, if people are trying to reconcile a marriage, you know, those are cases where the word reconciliation is used. It's used in a particular sense, I think, in relation to Indigenous law, and I'm not sure that it's the appropriate word. But it's, you see, we find ourselves, Aboriginal people in this century, we're waking up. Your generation is waking up to the fact that this country is around us. We're like this little house where a whole highway's been built over, and they've got our country, they've got everything, and they say, well, we should reconcile. And I'm going, well, let's turn the clock back to the beginning. Can we do that? No, we can't do that. Can we get our country back? No, we can't do that. So reconciliation, I mean, if you're trying to reconcile a marriage, you try to work through all this stuff and come out with a fair agreement, and that everybody understands too what the conflict's about. Not so when you come to Aboriginal law issues, because Aboriginal title has not been defined in a way that everybody understands what the hell we're talking about. It's not on the table that, okay, we're actually talking about getting our country back. Can we talk about that? No, we can't talk about that. Are we just talking about our village sites? No, oh yeah, well maybe just our village sites. So we're not coming to a one thought, a one mind, where we come together and we say we know what the conflict's about. So reconciliation in that environment, I think, is problematic. And when you talk about forming a protocol around reconciliation, we don't even have a shared understanding of our history, of what the hell's gone on over the last 150 years, right? I like what the judge said in Alberta. He said that often judges don't even understand the biases that they carry. And it's absolutely true that there's a huge gap between the visions of what's gone on over the last 150 years, between our perspective and the European perspective. And how do we reconcile that so that we can get to a place where we begin to understand each other? And I think the first thing that you got to do in a protocol is to say, okay, let's review what's gone on so far in this game. How come the score is 0 for us and 25 for you guys, right? Let's go on and talk about the referee. Was he fair? Let's talk about what the playing field was. Did we all have the same skates? How do you guys keep score even? Because without a better understanding of how we got to where we are, we're not going to decide or be able to clearly understand where we're going in the future. And that's been my problem with reconciliation, is that let's not talk about the past, let's talk about the future, right, in this vacuum. And we should pick out solutions from the air. And the simple fact is that Aboriginal people have a different way of perspective. We look at things differently. Because the trees are alive, because we talk to the trees, how can we talk about giving you a permit to cut all these people down, right? How can we talk about that when our perspective is we only take the dead ones, right? Would logging companies do this to the trees if they thought they were alive? Would fishing companies do this to the salmon if they thought that they were your brothers, as we do? Our perspectives are so diverse. It's so big. Reconciliation is complicated. I wake up in the morning and I talk about spirit. I think about, where am I going to go today? I look at there's an eagle flight. I go, well, okay, this is going to be a good day. I take my social cues differently, right? And so it's a real problem. And I don't know if reconciliation is the right word, but I guess it's the closest we can. But I think that we need the first thing is we better understand each other better. We need to have a better understanding. And when I talk about wealth, they talk about wealth, it's all the money in the bank. I talk about wealth as the number of grandchildren I've got. How much do they know about the history? How much you've grown as a person in your spiritual life. That's wealth. And our word for poor is salawa. It means you don't know anything. That's our word for that. So our definition about things ain't the same. And if we're not talking the same words, it's hard to do that. So we need to take some time to begin to understand each other a lot better. And then we can begin to talk about how do we reconcile the extension of British sovereignty to the reality of Indian title to our country. We're here to stay. Everybody is. But that reconciliation process is going to be based on our understanding as well. It's got to be based on the way I look at the world. Not what we learn in residential school, not what's in our bank account, but based on my history and what elders have told me. And that's a different ballgame altogether. I gotta shut up, right?
Oh, no. Okay, thank you very much. We have another question to your left.
Wait, Chukwinuk, Squatwin, Robert Phillips with the First Nations Summit, and also from Chikeskin and Canham Lake and SKOWKALE, Stalo. Yeah. So I give acknowledgements as well to Tsleil-Waututh, Musqueam, and Squamish on the territories that we're on. And I see Stephen every now and then out on his property sometimes doing things, and you know, we take great advantage of having a great leader like you, Stephen, and really appreciate all the work that you've done over the years, as well as the honorable judges as well. And I was trying to figure out how to acknowledge Judge Binnie, and he said, just call me Ian. So that was great. So that was excellent. But with that said, again, I'd like to thank BC Treaty Commission, because I don't know if I would have the opportunity to do that. So the leadership from Celeste and the commissioners is excellent, as well as the staff and Mark and everybody, Sashia, and all the staff that do a lot of the work behind the scenes. And I was also a commissioner for a number of years and a negotiator with the Northern Shuswap. And one of the big issues, of course, that always came up on the table is you're involved in a lot of negotiations, a very comprehensive negotiation with Canada and British Columbia. And a lot of times, you know, just like a hockey game or a soccer game, instead of playing one opponent, you're playing two opponents. And sometimes those two opponents are working together, and we're not allowed to share information among tables. And I know it's a challenge for the chief negotiators, because once you get into a negotiation, it's sealed down negotiation. You're not allowed the confidentiality reports that are there, and not able to share that information. So that's one issue that we really have to try to get around in order to work together. Sometimes we're played against each other. So in overlaps and in negotiations, because everybody else there's only so much of the pie that's there, and everybody is working to try to get their fair share of the pie. And that can take a lot of competition among each other. And I find overlaps one of the biggest issues and impediments to the BC treaty negotiations. And then as well, we're sitting there trying, as a principal, the First Nation Summit, meeting with BC and Canada, and it always seems like it's either BC is on the right track and Canada's off the rails. And then finally, now it seems that Canada is on the right track, and there's British Columbia over there now doing, you know, little agreements here and there. And a lot of times I say to people, it's not just treaties, because it's also in terms of other arrangements and other agreements that we're working on, that we hope to see that it's stepping stones. And as we know in British Columbia, treaties is a lot of negative words to it, even final agreement. It's not like a marriage, it seems like a divorce, as some say. So there's a lot of issues that we have to get through, and I know that we can go on. And I kind of waited till the end of the session, because I really was very impressed with the presenters, and I was also very impressed with the dialogue that was going on at the BC Treaty Commission Forum. So I was really taking notes and trying to listen and dialogue as well with individuals that I can, you know, get that information that was there. And Satsan started right off at the beginning, and he said, you know, does the summit come to the communities? Does the union come to the communities? I'm like, oh, Jesus, what's Satsan saying? But it's true in a lot of ways, because we get caught up in these meetings that happen a lot in Vancouver and Victoria, and we don't have those opportunities. As a commissioner, you do. You get to go to the tables, and you get to listen in on the negotiations. But I know a lot of times if myself as a task group member walked in, you know, you could tell there would be, you know, well, what the heck is going on here? Why is a task group member in attendance at the negotiation? So I think that's one of the things that we have to do, is start getting out to the communities, meeting with the people, and not only First Nations people, but the people, the general public, because there's a long way that we have to go with the general public to let them understand, but as well for First Nations. And I can't think of, I've been reading through the Silcotin Accord, And they still have to, when it comes to their lands, and there's a lot of great words in the SOCO team, but it still gets down to a negotiation. You can go to court, but you still have to negotiate. You can go to a protest, but you still got to negotiate. Waking up in the morning seems like a negotiation. So it all comes down to that dialogue and getting to a resolve. And again, Judge or Ian said, we are a nation and we are a sovereign. But how those details are worked out with Canada, especially in British Columbia, comes to a key point. So I don't want to take up any more time. Maybe if you got one word of advice from each of you, and I know it's just a very general thing to say, but if you got one word of advice to the technical people that are in attendance here, to the leadership that's in attendance here, I certainly would like to hear that before the end of the session. And again, Cookstam, thank you for everything you guys have done.
Well, I'll offer something, and it's in part perhaps a response to Judge Point. And I don't disagree with anything that he said about reconciliation and the need for better understanding. But the fact of the matter is that if we all wait for the level of comprehension that he is calling for between Aboriginal and non-Aboriginal, First Nation, Inuit, Métis society, these matters will not be solved, not only in our lifetime, but so far as I can see, down the road. Agreements are made between people who have quite different views, quite different interests. And it's not getting them on the same page in the way they look at the world as it is in saying, we have a problem, we have to solve it, and here is the basis on which we're prepared to go forward. It doesn't mean to say that at a much deeper level, reconciliation requires the sort of understanding that Stephen is referring to. But it means that in terms of this protocol that we were asked about, one has to approach it on the basis that it is important to get some sort of agreement and move forward and carry the communities into a better situation. In 1983, 84, I was part of these constitutional talks required by Section 37 of the Constitution, which eventually went nowhere, and there was a conclusion at that time that there was a big danger in trying to accomplish too much in a kind of one-size-fits-all, for example, protocol on reconciliation. That there are just too many differences with different groups, different communities across the country, that there had to be a more customized solution approached. And it was felt that a great opportunity had been lost in the mid-'80s because we were trying for these general principles to which everybody would subscribe. So my comment would simply be, first of all, it's important to try to get an agreement to move forward, and then perhaps once the sting has been pulled from the relationship, the groundwork is laid for a much better understanding of each other and what the interests are and the kind of history that Stephen referred to. And the second point I'd leave with you is that we've been down the road with comprehensive coast-to-coast-to-coast solutions in the Constitution, and it was just too big a problem to solve, and maybe it's a better approach to parcel it out and deal discreetly. Now, maybe the BC treaty process is broken down too far, has to be raised to a higher level of generality. But there's a great danger that if you bite off too much, then you wind up with nothing.
Yes. In the negotiation that we all want to see, I think something to keep in mind is that perspectives don't have to be positions. And we've seen the Supreme Court of Canada say in proceedings in the courts, judges should take account of the Indigenous perspective. And I can tell you that judges in some courts are consulting with Indigenous elders to try to become informed of perspectives, to try to come to understand perspectives. You know, there may be a perspective that there's no legitimacy to white occupation of the land. And it hurts no one to hear that perspective offered. And there's a basis, a rational basis on which that perspective can be held. But if it's a position, and if it's an object toward an outcome, there's no point in having a negotiation. It will fail. And if I were back lawyering and I accepted a retainer from an Indigenous group that said it's all or nothing, we'd like to go into negotiation, I would say, well, just go to court. See how you do, but here's the risks. So I can tell you, in the specific claims tribunal process, we invite the voice of the claimants on perspective. Even if it really does not assist in gathering up the body of information that is relevant to the particular issue, because it's important that people have their say and see that they're heard. And we have the unique ability with the specific claims tribunal to do this, and we do it. And a little example of, I think the other day it was mentioned, you know, the taking of an oath when you're testifying as a witness. Well, I showed up uncharacteristically early for a hearing at a gym at the Beardies and Okamasas Reserve in Saskatchewan. And a gentleman was coming out and he introduced himself as the interpreter. And we got chatting and I said, what are you doing here so early? And he said, well, I was here, you know, to smudge with the witnesses. And we had a traditional ceremony around that. Well, what was that in aid of? How did it relate to what we're going to do here today? Well, it's about truth-telling. It's a covenant to be truthful as we understand the truth to be. So I thought, well, okay. I went in and talked to the lawyers for the Crown and the lawyers for the claimant and said, here's what I was told. Let's dispense with the oath from the witnesses and simply have the translator explain what they did and why they did it. And the witnesses can simply say, yes, I was part of that. That's the oath. So I'm kind of wandering here, but I'm trying to illustrate that you could embrace a perspective and make it a meaningful part of a proceeding and a process, and negotiation is a process. So it's part of listening to each other. The other thing is that I don't think my friend Stephen intended to portray white people as so soulless that they would not value their families and their children, their grandchildren. In many ways, the average non-Indigenous person has very much the same interest as the Indigenous person. I mean, we, like you, love our families, love and practice our own customs and traditions. We've kind of gone astray, in my view, with consumerism and celebrity culture, but we're not all about that. And with the growing legitimacy of concerns around the environment, it seems to me we all have to move to a better place and start valuing the land for what it offers us. And this, as I understand it, comes closer to to the Indigenous view of the relationship with the land. So it may be that we're pulling closer together due to forces that have been beyond our control. Now, sorry to go on, but a word of advice. Well, some of you may have seen the old movie with Clint Eastwood, The Outlaw Josie Wales. And Chief Dan George had a role in that, and he related a meeting with the president of the US, I think it was Andrew Jackson, and he said, and the president urged us to endeavor to persevere.
A word of advice is to try to maintain your same negotiators. Try to get some consistency and not change them. It means that they might get pretty old in the tooth, but to try not to change your negotiators. Another piece of advice is to try to work on your overlaps. Try to resolve the overlap issues. My suggestion is that a tribunal ought to be established to work with the various nations to resolve the overlapping claims, the national overlapping claims. And that those issues ought to be put to bed so that nations can go forward with their claims without having the problem of overlapping neighbors' issues. The other thing is bring your people along. Forrest Wacom told me when I got into chiefing, he said he got 25 years into on the chief, and he turned around, the people weren't there, and they just moved too quickly. The leadership was moving quickly, but the community was not, and it's so important. Your community engagement to help them understand where you are in the process as you go along. I remember going out to one of the tables and they had a 300-page document. They were just beginning, after 5 or 10 years of negotiations, to try to explain that to the communities. It's too late. It's too much, so. The other thing is, I think that your elders are so important, because your elders, in the end, pack a tremendous influence in your community, and wherever possible, whenever necessary, where we can, to engage your elders, to go and talk to them, help them as best as you can to understand what you're doing, Because if they take offense, they'll stop talking to you, and then now you're in trouble, right? And I try to maintain that connection to the elders. I also formed a youth council when I was the tribal chairman. I brought in members from every community that were young people. We were grooming young people to run meetings. We were grooming them to run, to see how meetings were held, to train them for leadership. We shadowed them with other elders, and we wanted them to go to conferences to see how they were doing. And some of those young people today, I mean, they're just moving very quickly. This notion of training the next generation, because what we were doing is, I was a logger, and one day I was on council. I had no idea what people were talking about. It took 2 years to find out what's a resolution. What are they talking about? What is the Union of Chiefs? What is this? And many of the people that I started with stopped right away because they didn't get it. And you need to train your young people in so they understand what we're talking about in these rooms. Don't leave it too long. Bring them up and bring them in and send them in for training. My other advice is, whatever you do, base it in your own culture, base it in your own perspective. You can't talk from the other man's table. You have to talk from yours. That's the one you know. And your strength is there. Your strength is there on your side. The white people are here to stay. They're, in fact, our brothers. That's the way we look at it. We can't go on in the future with animosity, but we can't be afraid to say what's on your mind, too. We've been hurt many times, many ways. But we need to change. We need to turn the page on the past. We need to try and find a way of putting it behind us through like what they've done with the reconciliation for the residential schools. We can't be angry and marching all the time. We have to try to find solutions. But what I say when I mean we need to better understand each other. We've been learning about the white people all these years. Maybe it's time for them to learn about us. Haichkasya.
Thank you very much. We'll have one final question from Leah.
Thank you. Thank you for your comments so far. My question actually goes along with what Stephen Point as well as Justice Slade have just recently touched upon. In 2012, at a continuing legal education conference, former Supreme Court Justice Lance Finch gave a paper called The Duty to Learn, Taking Account of Indigenous Legal Orders in Practice. It was an amazing paper. And in part of it, he said that the honor of the Crown, which we know includes the duty to consult and duty to accommodate, also includes the idea that all members of the legal profession have the duty to learn, which is just what Grand Chief Stephen Point was just saying. And that includes the understanding that there is a legal obligation to take account of the Aboriginal perspective, how it engages the principles in the rule of law. If the rights of all Canadians are to be guarded by the courts, then the courts must necessarily be capable of understanding those interests. So he's saying, if we all, as First Nations, need to learn about their law and how they do things, if the court is to protect us as well, it's their job to learn about all of us. And I want to know how you think that people in your positions can help facilitate that for our legal profession?
Well, I think one of the calls to action in the report of Justice Murray Sinclair is a call to lawyers receiving, law students studying the history of colonization. Of course, there's much to be said for starting much earlier, and I think that's another call to action in the report to offer instruction to students of all backgrounds in the history of the colonization of Canada and Indigenous state relations. As I mentioned, at least in one court that I know, the federal court, judges are reaching out through the Indigenous Bar Association to have sessions with elders to hear perspectives and hear their personal histories and the histories of their peoples. So there's a lot that I think can be done. Now, if I may, I'm glad you, and forgive me, I don't know your name, but you asked earlier about how can Indigenous peoples today organize themselves from a disadvantaged, fragmented existence to meet with treaty partners toward lasting agreements. And I mean, it is certainly true that the operation of the Indian Act and a whole lot of other things has balkanized and busted up Indigenous peoples in their traditional collectivities, and isolation from resources has brought about poverty. So it's a really tall order to organize, to mount an effective negotiation. The remarkable thing, though, is that despite all of this, it has been done and has brought about resolutions. Now, it does seem to me that in BC, the fragmentation is at its worst. 234 bands. Who knows how many true Indigenous nations there are? The map that I showed yesterday, done by the Union, suggests 23. The Supreme Court has allowed us how Indigenous political and cultural organization does not create a single definition of what the proper claimant group is. But in my personal view, I think you've got to do a lot better than approaching this treaty table as a band. Fundamentally, a band is a creature of a federal statute. Part of getting out from under that is for Indigenous peoples, in my respectful view, to see themselves as nations bonded by something other than federal administrative convenience by delivering program services to bands. And you know, I think that I think that with respect, you need help with that. I think there's got to be a way of perhaps a tribunal of your own creation to facilitate the coming together of those people who can constitute a nation as the correct group to sit at a treaty table. And this greatly benefits everybody, because then the Crown in its federal and provincial incarnations knows that they're dealing with the correct nation, dealing with the nation toward an agreement that can hold over time. Otherwise, they don't, and neither do you. So I'll leave it at that. Thank you.
I was approached by the Law Society here in British Columbia. They're actually looking at that recommendation with regards to how do we bridge the cultural gap, or how do we inform judges and lawyers about the Aboriginal perspective. And I think they're calling together some law schools together now, and they're going to have another forum on this issue. I think there's been a lot of focus now on traditional laws and traditional policies and how those laws are established. And because that's going to inform conflict resolution in communities, is also going to form your constitution development. And so I think that's an exciting development. I think that's something that we're going to see happening is perhaps some development courses at the Law Society itself for lawyers and law students at the law school. So I'm looking forward to that.
Well, I think anything that educates lawyers is for the good. I think in this process, the problem is not so much educating lawyers and through lawyers, judges, although that is important in terms of the jurisprudence. Seems to be the basic problem is that the politicians are not really on side at moving this agenda. Now, Mr. Trudeau says that he is on side, and I guess time will tell what he's prepared to do, whether it's all talk or whether there's some real push that's going to happen. But generally speaking, I mean, going back to again, the 1980s when the Section 35 came in those talks, there was real interest in the general population about addressing the concerns of Aboriginal peoples. And that somehow has declined over the years, and I don't know why it has declined. It's a much hotter topic in British Columbia than it is, for example, in Ontario. But politicians respond to the popular mood. If people are placing a priority on dealing with these issues, they will be dealt with. If the politicians feel the pressure's all on creating better transportation and whatever, then that's where their focus will lie. So I think it's important to have this discussion about lawyers taking a more educated interest in Aboriginal law, Aboriginal practices, cultural history, and the other things that have been referred to. But there really has to be some kind of a push in the political arena to bring the issue forward. Again, BC is a special case. It's a hot issue out here, so you may not be as concerned. But I do feel in the rest of the country that it's kind of gone to sleep, and that there has to be much more activism on the part of the Aboriginal communities to put pressure on the politicians to get moving. And when you consider that, you know, Trudeau, fine, he's talking about BC, but he's got the rest of the country to worry about. And if the rest of the country is asleep, it's not good for pouring the resources into the resolution of First Nations issues.
Okay, just one final comment, not a question, but a comment.
Thank you. I appreciate the comments that the judges have given their perspective, but I want to pick up on the last point about education. I think it behooves this country to have knowledge of who their citizens are and who their original citizens are. And I think that every province should have curriculum as part of its core so that all of us can see ourselves in Canada here as citizens, as people who want to coexist. And I think it really speaks to the fact that the country is sleeping. And while things are lively here in British Columbia, I'm the mother of a graduate this year, and all her life in school she's wondered, where am I in the history books? How come nobody talks about the Giksan? How come my neighbors who are my best friends don't know about me? And I think that the push should come from the legal side of it, but it should also come from the societal side of it. Because in the pedagogy of the oppressed, if you bring us all up to your standards, you'll all thrive. And I think that's really critical if we're going to be partners, if we're going to collaborate. The Truth and Reconciliation, all of the cases that have come forward, all of the reports on the committees and the work that's been done all speak to the history of Canada, but ignoring the original peoples of Canada. And that oversight is coming forward in the law now. That's why we're before you. Those of us that can afford to go to law, to go to the courts, that can pay the price to have their recognition of who they are as a people. So I think it would serve the humanity of this country to have that knowledge in play all the time, so that my neighbors actually know who I am. And that when I bring a child into the world, that child is respected for who she is and who her identity is. And I think that's really important in this picture as well. So it can't just be in the legal profession. It has to be in society at large, because now you're turning on us, and not you, but society. It's your job to educate people about you. Well, I'm sitting here breathing and existing amongst you. How come it's all on me always to justify who I am? Thank you.
Thank you very much. So as we move to close, I would like to address our judges and thank you so much for your time, and just ask if you have any final words that you would like to share with the group as we close.
Well, only to say that it's a huge privilege for me to be here and to hear the commentary and the insights that people have offered, both from the podium and from the floor. And it's just a pity that this kind of knowledge is not more widely available outside this room to bring about the kind of cultural understanding that we've been talking about the last few minutes.
For me, it's an honor and a pleasure to participate, to be asked to participate in this, and to hear what's said, as well as offer something. It's a particular joy to me, though, having practiced here in British Columbia and done legal work for many First Nations over a period of 27 years before 2001, when I went to the court, to see so many old friends, familiar faces, and among the newer, fresher faces. It really kind of lifts up my heart to see the mix and to run into people that I know from from my past involvement. It really is makes me happy. And speaking of happy, Tom Happynook, Huayet, I was chatting with him earlier and about the very same thing that Stephen raised, and that is keeping the community informed as you go along. And I think if any of you are engaged in negotiations, you may want to look at what they've done, and if you haven't established your process, because they had, I think, a better than 90% turnout on the vote and a higher than 90% vote in support of entering the Minoth Treaty.
Okay, in closing, I want to apologize, first of all, for coming in late. It only reinforces an old stereotype about late Indians, right? I remember getting to the Olympics, and Don Burnstick made a comment about it when the Olympics were starting, and the Lieutenant Governor was on the bus with Gordon Campbell and the president of the Olympic. We were all on the bus that kept going around and around. We finally came in late, and Prime Minister Harper was sitting there with his wife all by himself for quite a long time as the opening ceremonies were going on. It looked like we had abandoned him. And then we all came in with our Tim Hortons cups. He says, "Here the Indians are, they finally got there." With the chief with the swallow-tooth and the muskrat and myself. And it's disrespectful to be late, and I apologize for that. When I was invited to this panel, they said it was at 3:30 initially, and Mark moved it up, and I had a meeting intervening. But I wanted to be here with you, and it's an honor and a privilege to be here with both of these honorable judges, and to be here with all of you as well. And I just wish you all the very best. And if there's anything that I can help you with, because of the things that I've done, I'd be pleased to do that. Thank you.